for hanging on. So we're gonna you're gonna run through the right to farm stuff with us?
Yes, I'm going to review the Vermont right to farm law. Then I'm going to compare it to 3 or 4 other state laws to show you the differences and some of the reasons why farmers particularly, are looking for a change in Vermont's right to farm law.
And next week, we're gonna have a group in and that are interested in this. And that's why I wanted the committee to get a little overview and or see where we're headed with this before we get the public in. So thank you, Michael.
So this is Mike O'Grady with Legislative Counsel. There should be on your committee website 2 documents that I provided. One is an enormous 200-page plus document, which lists all the states, every state's right to farm statute. It's there for context. I'm not going to review that, but if the discussion continues throughout the session, I think it'll be a good resource for people to look at. The other document is called the Comparison of Right to Farm Law to Other States. Now, I can either share that on the screen or you can just look at it on your own screens and I will walk along with you, whatever your preference.
Whatever's easier for you, Irene.
I wonder if the public is watching, if they would find it helpful to have it on the screen.
On the screen.
I don't know if we have any
Sure.
public watching, but I mean, just as a good practice, if somebody's watching this meeting afterwards.
We can do it on the screen, sure. Does Michael have access?
Sure. Yep. I
Yeah.
will share my screen right now.
No, you may have to refresh it.
Okay. Can you see my screen?
Yeah.
Okay. So the first page is Vermont's right to farm law. It's called the Nuisance Suits Against Agricultural Activities. And the first thing I want to highlight is the legislative findings and purpose. The purpose as set forth by the General Assembly for this law is that agricultural activities are potentially subject to lawsuits based on the theory of nuisance. And these suits encourage and could force premature removal of farmlands and other farm resources from agricultural use. And it is the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. So it's the protection of agricultural activities from nuisance lawsuits. And when you look at other state statutes, that is effectively the purpose for every right to farm law, to protect farms from nuisance suits. You'll then see a definition section defining what is an agricultural activity. I'm not going to focus too much on this, but I would note that last year, you added the definition of farming under Act 250, that's subdivision 3, farming defined under 10 VSA 6001. And then you added a new list of activities, agricultural activities as defined in 6 VSA 4802. The 4802 definition is a more modern, a more comprehensive list of farming activities. It includes things like change of use, change of equipment, change of crop. So those activities would still be or would be now recognized as protected under the right to farm. And that is how most states define agricultural activities in their right to farm law. Well, then you come to where Vermont starts to diverge from most states, and that's in 5753. And this is actually the core of the right to farm law. This is where the protection is allegedly afforded. And it provides that agricultural activities, those definitions that we just kind of looked at, shall be entitled to a rebuttable presumption that the activity does not constitute a nuisance if the agricultural activity meets all of the following. Now, a rebuttable presumption means it's presumed not to create a nuisance, but it can be overcome. That presumption can be overcome, and we'll get to how that's overcome in a second. But in order to qualify for the rebuttable presumption, the agricultural activity has to be conducted in conformity with federal, state, and local law and regulation, including the RAPs. It has to be consistent with good agricultural practices. It has to be established prior to surrounding non-agricultural activities, and it has to not significantly change since the commencement of the prior surrounding non-agricultural activity. So let's focus on these for a minute, and I'm going to use the Erie Point case, the Worsabelt case, and the opinion by Judge Teachout, kind of highlight some of the issues here. And the one that I really want to highlight is that it is conducted in conformity with federal, state, and local law. In the Erie Point case, the Worsabelts argued, hey, we comply with the RAPs, we get our permit, our medium farm permit and our large farm permit, and we haven't had any agency of agriculture enforcement actions against us. We're in conformity with the law. And the court said, I don't know if you're in conformity with the law. Just because there hasn't been an enforcement action against you doesn't mean that you're in conformity with the law. Conformity with the law is a fact-based assessment that I would need to go through in order to determine if you're in conformity with the law. And then she said, by the way, you just entered into an enforcement settlement agreement with the Agency of Natural Resources for some wetlands law provisions. So you weren't in conformity with law. So she basically said that compliance with the RAPs and lack of an Agency of Agriculture enforcement action isn't good enough to determine whether or not you are in conformity with law. And I'm going to come back to that point when looking at another state, specifically Louisiana. The other thing I want to talk about, it has not significantly changed since the commencement of the prior non-agricultural activity. As I just noted in the definition of agricultural activity that was added last year, some of the things that are recognized is that farms have to adapt. They have to change their practices. The Agency of Agriculture and the General Assembly encourages all farms to diversify, and that means changing their crops, changing their equipment, etc. And does that mean that change mean that they've lost their protection from nuisance? According to Judge Teachout, it may, because she said that when the Worsabelts put in 2 new manure ponds, that was a significant change. And then that was something that led to the interference with the use and enjoyment of the neighboring property. And that's what a nuisance is: interference with the use and enjoyment of your property by another. So Judge Teachout said that the ammonia smell that came from those 2 new manure pits was a significant change, and that it interfered with the use and enjoyment of the neighboring property. But those 2 manure ponds were included in their nutrient management plan, which were part of their permit, which was part of their compliance with law. And so it's a little bit cycling back on each other. Like, they conform with the law, they got their nutrient management plan, they included the new manure pits in that, they were applying according to their manure plan, but that wasn't good enough to show compliance with the law, and it was a significant change. And so that creates anxiety among farmers. What do they do in order to diversify and meet economic needs while still conforming with state and federal law? And then the key aspect of Vermont's right to farm law that is different from many, not all, but many, if not most, right to farm laws across the country, is the ability to overcome the presumption that a farm is not a nuisance. And that is that subdivision A2, 5753A2 at the bottom of page 1. The presumption that the ag activity does not constitute a nuisance may be rebutted, may be overcome by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. So not just any use and enjoyment of the neighboring property, but a noxious and significant interference with the use and enjoyment of the neighboring property. Many states don't have that kind of standard. And I'm going to stop here and ask if you have any questions.
Brian?
What does it mean when someone's coming to a nuisance? That was something that I know was brought up in a meeting I had. Can you explain that a little bit?
Sure. So coming to the nuisance is the concept that an activity exists, and it exists in its state for years, but then somebody moves next to that activity and then alleges that that activity is a nuisance. They came to the nuisance, right?
Yeah.
The nuisance existed before that neighboring subsequent use. That's coming to the nuisance. And that's where right to farm laws were originally arose from. A couple of cases from out west where retirees started moving into the area and started building next to these large scale cattle lots. And the
Right.
cattle lots hadn't changed their operation, but the retirees were alleging that they were a nuisance. And the cattle lot said, you came to us. You should have known that this was the condition of the use of the land here. And the courts upheld that. The court said that the retirees came to the nuisance and they couldn't bring their claim.
Yeah, I think my issue in this is, okay, so just thinking of an event with a shooting range in Shaftesbury, I think it was, where people moved in knowing the shooting range was there, but then it expanded dramatically. And so I'm thinking about that regarding, a farm. Do right to farm laws allow, somebody to spray pesticides, spray herbicides? You're trying to raise a couple of kids, you're having a picnic in the backyard, all of a sudden the herbicides and pesticides come over. Does that hamper the ability of that neighbor to say, hey, yeah, I don't want herbicides and pesticides blowing on my state?
Well, one of the things you did last year is you expanded the scope of the agricultural activities that qualify for protection. And one of those things that is now protected is the use of pesticides.
So just so I know, where was that? What bill was that in?
That was in Act number 162
It was
last
in
year.
that one that you were supposed to read. that you never
Which one
read.
was it, Mike?
Act number 162.
Thank you.
Probably the housekeeping bill, or is it, or?
It was either the miscellaneous bill or it was in the ag water quality
So just
bill.
so I know, if you do have a farm, if you are raising a family next to a farm and they do spray herbicides and pesticides, that family really has no possibility of getting somebody to stop? Is that accurate? Based on that bill?
If a person is a certified applicator and they
Yeah.
are applying pesticides on their property in conformance with the pesticide rules, they're within their right to do that.
Okay. Thank you.
It started as a Senate bill, 258, but it was Act 162.
So that was the ag water quality bill then, not the miscellaneous bill.
Did you have a question?
Yeah, can you talk a little bit more, because I'm a little vague on when we say rebuttable presumption, and then we go down into 2, and we talk about obnoxious and significant interference.
Right.
What does that mean?
So that's a great question. And I think it highlights kind of a misunderstanding about what the right to farm law does. So I think some farmers think the right to farm law means that no one can sue them. And that's not correct. Somebody can still sue a farm and bring a nuisance claim, but the standard is what this law does is it sets the standard that the court is going to use in determining whether or not to go forward with that nuisance claim or not. And so if that nuisance claim is brought, there's the presumption that the that the court is supposed to have that the farm is not a nuisance if they're meeting those 4 criteria. But the plaintiff, the person that brings the nuisance suit, can show the court that even if the farm meets those 4 criteria to maintain the presumption of not being a nuisance, that they are still a nuisance because they have a noxious and significant interference on the use and enjoyment, or they have a substantial adverse effect on health, safety, or welfare. So the Airy Point case, the Worsabel case, Judge Teachout said, hey, the Worsabels don't qualify for the presumption because they weren't in conformity with law and they had a significant change. They don't get the presumption. But then she went on to say, even if they did, their interference with the neighboring property owners by both the increased flow from their tile drainage and from the increased ammonia smell from the manure pits would have overcome the presumption because they would have had a noxious and significant interference with their neighbor's property.
So I kind of get, but to nail this down, so, because I don't speak lawyer all that well. Because of their manure pit, if it's bed and breakfast or an Airbnb that's next door to it now, and it's a smell, you could still be sued for that.
You can still be sued for that, right? It doesn't, that's,
Yeah, you are.
somebody can still bring the suit. It's whether or not the court says, no, the suit can't go forward or not. And here the judge said, hey, you didn't qualify for the presumption, so I'm not gonna tell the plaintiff they can't go forward. And even if you did qualify for the presumption, the plaintiff showed enough facts in order to overcome the presumption. And that's, I think, a key part of it. It's the facts. The facts of these cases are really what drive whether or not a court's going to allow them to go forward. And that's honestly, that's an argument that I've heard the trial lawyers make. It's like, these cases don't get to this point that the Worsabel farm did. There aren't that many right to farm cases that come up because the facts never get to the level where a plaintiff is confident that they can succeed. So if you're a plaintiff, you go to an attorney, the attorney that you want to bring the nuisance claim is going to look at the facts and say, I don't think you're going to overcome the presumption. But here, those attorneys for the plaintiffs probably said, hey, there's enough facts here that we can bring this claim.
Okay. I'll set, right?
Yeah, I'm a little clear.
Yeah, he's a little bit, he's catching on, Michael.
I'm a
little
foggy
bit.
kid.
Well,
but-
Senator Westman, let's look at some other states and see how it becomes clearer in other states how the protection attaches in those states. And
Okay,
so
yeah.
for example, Kentucky, there's no presumption here. You don't get to rebut anything. It just says no agricultural, silvicultural operation shall be or become a nuisance or a trespass. So it's not just nuisance protection in Kentucky, it's trespass Kentucky. If by any change condition in or about the locality, if they have been in operation for more than 1 year and the operation was not a nuisance at the time the operation began. No rebuttable presumption. It just attaches. You just have to have been in operation for a year and you had to have not been a nuisance when you started.
You like this?
Yeah, I like.
Yeah, Reggie wants to move
Freewheeling.
that we adopt Kentucky.
Right, so think about the issues where the court found the Worsabel didn't qualify. That that they were in conformity, that they changed. That's not part of this, right? They had to have been there for a year, and they had to have not been a nuisance when they began. So this is probably one of the more protective. It's not the most protective. I'm going to show you the most
The
protective.
next one down even looks better.
Well, and then you get to Louisiana, and no agricultural operation shall be deemed to be a nuisance in any action, right? If the agricultural operation is conducted in accordance with good, generally accepted ag practices, and all the following applies. They acquired the interest in the land to be affected. The person bringing the action bought it. They came to the nuisance after the ag operation was in effect. The ag operation was established prior to any change in character of the property next to it. And the agricultural operation has existed for 1 year or more, and the condition or circumstances alleged to constitute a nuisance have existed substantially unchanged since the established date of operation. So basically, if you've had these conditions or management for a year, and somebody has come to next to you, they don't get to bring a nuisance claim against you. It's just not a nuisance. I'm going to skip for time reasons to my last state, and that's Oregon. And so I want this, in my opinion, is the most protective of farming operations, and it says, no farming or forest practice on a land zone for farm or forest use shall give right to any private right of action or claim for relief based on nuisance or trespass. So again, nuisance or trespass protection. And shall not apply to a right of action for relief for damage to commercial. So basically, there's no right of action unless you kill somebody or injure them or damage their commercial agricultural products. And that's it. That's it. Like, that's the only condition that would allow that nuisance or trespass suit to go forward. It's not about you were established prior to, you changed. It's like, if you're on zoned farmland, they can only sue you if you kill or injure them or you damage their commercial agricultural product.
Now that Richie wants to amend his motion, to go with Louisiana.
To Oregon.
Yeah.
So, but I do want to show you how Oregon, their standard changes depending on where the farm is located.
Yeah,
They do, if the land is not on zoned farmland, and it's on what they call like the urban boundary land, where you're basically within that land that's zoned for mixed use. Then they say, hey, same thing, you don't have a right of action for nuisance or trespass unless you damage or kill someone, except where that protection doesn't apply where a farming or forest practice existed before. So you basically have this ability to show on land that's not zoned for farming that it has significantly changed, and that allows that person to bring a claim when the farming operation has significantly changed. So that's another thing to think about. Is it appropriate to have different standards depending on where the farm is located as opposed to what the farm is doing?
See, if we had agricultural zones, we could do that, but I don't believe we have.
You do have agricultural zones, but what is different from Oregon versus Vermont is Oregon has mandated zoning, right? Vermont doesn't have mandated zoning. So there are towns in Vermont that have agricultural zones, but they don't have the same effect under statute, state statute, that an agricultural zone could have in other states like Oregon. So that's a key part of the difference here, is that because there's mandated zoning and because all municipalities in Oregon can benefit from the statutory protections for certain types of zone land, it's used more. And therefore, these types of laws have more benefit for whomever they're regulating, but here for a farmer. So you'll see no rebuttable presumption in any of these. Most of the time, it's just a statement that there's no nuisance action shall be brought if the conditions are met. Looking at Pennsylvania, which we skipped over, one of the key parts of theirs is you don't get to bring a nuisance action if the farming practice has been incorporated under your nutrient management plan. So look at the Vorsabels. They had those 2 new manure pits and the land application under those 2 manure pits in their nutrient management plan that was approved by the Agency of Ag. Maybe in Pennsylvania, they would have received the benefit of right to farm protection that they did not receive in Vermont.
So, Michael, I was trying to quickly read Oregon's. It looked like there was a November 4th, 93 date. Is that when the zoning went into effect?
Yes, but remember, it's November 4th, 1993, or the date in which the subject land becomes part of the urban growth boundary, whichever is later. So
Yeah.
if the basically that land use boundary changes and it comes in and incorporates the farm, then that farm still gets that protection after that later date.
All right, so they're grandfathered in, yeah. But so what was Oregon before November 4th, 93?
They didn't have that mandated state zoning, so it was kind of,
Wide open?
town by town kind of thing.
But to correspond to that, isn't our law, our right to farm law relatively old too? Like 20 odd years or something?
Yes, it's before that. I think it's 1982. Let me look. The first time it was enacted.
I think that was the first bill I recorded.
Did, when I go over to upstate
Yeah,
New York. they have the right to
1981.
farm- They have right to farm towns. Do we have anything like that in Vermont where a municipality sort of takes control in some regard? Like Cambridge, New York, you drive through, it says, welcome to Cambridge, New York. It's a right to farm town community.
Yeah, and that designation has different meanings in different states. It can mean in a state where you have right to farm based on zoning, the ability to give that farm protection. In some states, it's really just a notice to people that are going there, residing there, moving there, etc. That farming is supported and protected.
And so in our law that we're trying to update, is there time for a quick overview of that, Michael?
Of Vermont's law?
No, the redraft that you've done.
Oh, of the redraft. I did not send that to you, but I can right now.
Just a quick overview, so next week when we get to talking about it, the members, they know now what other states have done, and just a quick overview of what we talked about.
I can say that it follows the Kentucky model of being short and simple, removing the rebuttable presumption, but it adds additional provisions in it. basically that you have to be in compliance with your required agricultural practices or your other relevant ag water quality requirement, your MFO permit or your LFO permit. So that's really, it follows the Kentucky model, but adds a little bit of kind of Vermont specific criteria of compliance.
But it would offer farmers more protection than they have now.
Well, it takes away the presumption, and it takes away the ability to rebut it. It just provides that it's not a nuisance or a trespass if it meets the conditions, just like Kentucky stuff.
It's a more fair way of dealing with it than Louisiana or Richie's other state. You know, farmers still have to, you know, meet certain standards but it protects farmers against a wealthy neighbor blowing in and causing all kinds of grief for I mean, some farms can't afford, you know, lawyers and all that, and the last crew we've only, how many, do you know, Michael, how many cases we've had in the 30 years we've had the law in the books?
Not that many, but it's also hard to tell how many there have been, because for the last Superior Court cases weren't reported and published. So for the first 20 of the last 30 years, you'd have to have heard about it, had to contact the court in order to get a copy of it. But now the Superior Court cases are winding up on Westlaw. You can see them there. The courts are also publishing them on the web. There haven't been that many in the last 10 years. The ones I can think of are the Airy Point Borsville case, Trickett versus Ox. That's about it.
Yeah. Brian?
Michael, could I get what the law looks like now, a bit of a side-by-side, and what we would be moving to understand some of the moving parts? I know this was tried last year a little bit. I know judiciary raised some concerns. I'd love to just understand that sort of, hey, this is where we're at, this is where we would be going.
Sure, I don't have that right now, but I can.
Yeah, no, whenever, sometime
put
next
that
week
together
would be great.
pretty
We
easily.
could talk about
Yeah.
it.
Sometime after we voted the bill out, Michael.
Yeah, Sears said this morning, first thing he said, watch that right to farm bill.
Oh, yeah.
I'm gonna stop sharing my screen. So I just sent.
Did
I
you
just
hear
sent-
that last motion I made?
Yes, I did.
No, I think what we're trying to do is only simplify the language and shorten up, you know, instead of a page and a half or whatever, shorter.
Oh, no, not on
more
this
to
one.
the point version.
Yeah, I'm not this time.
So, next week, Michael, we have you scheduled to kind of go through the redraft when we have witnesses here.
Yep.
And maybe if you're gonna send Brian a copy of that, like side by side, you could send that to Linda and she could forward it, give it to all the committee members.
Sure, will do.
Thank you.
And Michael just sent me the bill. And I'll put that on today's webpage. Sure.
Thank you.
The new
The
draft,
new draft.
yeah. So are you keeping busy yet, Michael?
I'm a little busy.
Yeah, well, yeah, we'll probably, once we get through our introductions to the different areas that we work with. We'll probably have some work for you to drafting and fixing up old laws and creating new ones. We love creating new ones. So we'll stay in touch. Did you have anything else for us, Michael?
Not right now. If anyone's interested, I can send you the Airy Point versus Worcester decision. If that's
Sure.
It's-
That'd be great. Yeah,
about
thanks.
35 pages long.
Oh,
So,
Yeah, you read that over the
I was
weekend,
excited.
right after church on Sunday.
okay. I'll send that to the whole committee and CC Linda.
Yeah, anything else?
No, thank you. No.
Well, thank you very much, Michael, and have a good day.
You too.
Ready to stop the stream?
Pardon?
Should we stop?